Good evening. I'm Wendy Perdue, Dean of the University of Richmond School of Law, and I'm so pleased to welcome you to our first ever virtual Emroch lecture. Although we typically enjoy coming together in person for this event, this new virtual format has allowed us to welcome more attendees. I'm happy to announce that we have record attendance this evening. This lecture series is an opportunity for us to hear from thought leaders in the legal community and beyond, and to engage in conversation on some timely and important topics. Tonight we're joined by Guy-Uriel Charles, the Edward and Ellen Schwartzman Professor of Law at Duke University School of Law. Professor Charles teaches and writes about constitutional law, election law, campaign finance, redistricting, politics, and race. He's co-director with Mitu Gulati of the Duke Law Center on Law, Race, and Politics. Professor Charles has published over 30 articles in journals, including the Harvard Law Review, the Cornell Law Review, and Georgetown Law Review, among others. He is co-author of 2 leading casebooks and 2 edited volumes, and has been visiting professor at Harvard, Berkeley, Georgetown, Virginia, and Columbia Law Schools. Professor Charles received his JD from the University of Michigan School of Law and clerked for the Honorable Damon J. Keith of the United States Court of Appeals for the Sixth Circuit. While at the University of Michigan, he was among a group of students who founded the Michigan Journal of Race and Law, and he served as the journal's first editor-in-chief. He's a past member of the National Research Commission on Elections and Voting and the Century Foundation Working Group on Election Reform. Prior to joining the faculty at Duke, Professor Charles taught at the University of Minnesota Law School, where he also served as interim co-dean. His talk tonight, Professor Charles brings attention to a very timely topic: whether we can develop a constitutional framework to meet the call for racial justice in the United States. We're honored to have him here tonight to share his perspective and his expertise. Please join me in welcoming Professor Guy-Uriel Charles.
Good evening. I am so happy and pleased to be with you this evening. I wish that it were in person. I am so grateful to the Dean for extending this invitation, and to the faculty at the law school for also extending this invitation. It's a wonderful group of people, wonderful faculty, and I only wish that I could be engaging with all of you, but unfortunately, given our current circumstances, this is the moment that we are called to. So thank you so much for listening and coming this evening for this virtual talk. I want to begin with the following story. There's a Black male running down the street. Someone called 911 to report that there's a Black man running down the street. A different person called 911 and reported that there is a man in a house right now. The dispatcher asked whether the man was a trespasser. Was he breaking in? The caller replied, no, the house is open. It is under construction. The caller then said, he is running now. The dispatcher asked, well, what is he doing? And the caller said, he is running down the street. Now, most of you have probably recognized that what I'm describing are the events surrounding the murder of Ahmad Arbory. When I first heard the story, I was struck and fixated by this following statement. There's a Black man running down the street. The statement was uttered as if its implications were self-evident. There's someone who does not belong on our street. And the statement did not express that there was any objective wrongdoing. It was simply a Black man running down the street. There are 2 elements here that I find fascinating. How do we know he does not belong? Race is the marker and indication of belonging or exclusion, and the idea of our street. We know this man does not belong because he's Black, and we know that he does not belong because he's here in our space. race performs as both the marker of inclusion and exclusion. I was struck by this frame, not simply because of the horrific outcome, but because it reflected one of the deep struggles of the Black experience, how one's Blackness is perpetually a marker of otherness, and the space in which Black people find themselves, that space is never quite their own. The task of Blackness is often to perpetually make the case for belonging. Conversely, whiteness is often viewed as a marker of inclusion and ownership. Whiteness is imperceptible. It is an inherent claim of control, thus our street. As a Black man, I have many stories about how my race marked me as other. Stories about being stopped by the police, stories about mundane tasks such as shopping, stories about being a law student, and yes, stories also about being a legal academic. Every Black person in many walks of life has these stories where your race indicated to someone, perhaps even a well-meaning someone, the false signal that you did not belong. I'm not here to regale you with my stories. I am here, however, to invite you and me and us together to think about what it would take to recreate an American polity in which race was no longer a marker of inclusion or exclusion. I'd like to have us imagine what we would do, what we would have to do, and what ways would we have to talk, what we would have to change so that we, the people, no longer includes, subconsciously or consciously, the adjective and modifier white, we the white people. As a constitutional scholar, I view the otherness of Black people and people of color as related, if not deeply rooted into our constitutional structure, our constitutional history, and our constitutional doctrine. We have a constitution of contradictions. And so what I want to spend the rest of my time talking about this evening is how this constitution of contradiction leads us to othering folks on the basis of race, and what we might do, what might it take to change that framework. So consider the fact that ours is a nation that was founded on the theory of liberty, and thus the Declaration of Independence declares all men and women are created equal and endowed by their creator with certain inalienable rights. The Preamble, we, the people of the United States, in order to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution. James Madison said, the Constitution is the safest method for the preservation of dignity, liberty, and happiness. So on the one hand, we have a Constitution that is framed, a history that is framed around liberty. On the other hand, the Constitution is also a compromise with slavery. The Constitution protected slavery without using the term. So here are some quick and dirty receipts. Article 1, Section 8 granted Congress power over slave insurrections. Article 4, Section 2, Clause 3 provided that slaves who escaped into free states remained slaves. Article 1, Section 2, the so-called 3/5 compromise, counted slaves for the purposes of representation in the House as well as the Electoral College. Article 1, Section 9 prohibited congressional abolition of slavery for more than 20 years. Article 5 precluded any constitutional amendment that would impair the slave trade. So on the one hand, we have a constitution that is birth and liberty, but on the other, we have one that has made its peace and compromises and was founded on the basis of slavery, the antithesis of liberty. The contradiction within the Constitution creates a paradox. And the question for us today, the legacy with which we live, is how to reconcile this commitment to both liberty and anti-liberty, this commitment to freedom and its opposite, especially racial subordination. Can the Constitution of liberty also facilitate white supremacy? And so that's the question with which I want to begin this evening. And I want to start at a place that those of you who are familiar with the Constitution and who are constitutional law students may find quite familiar. Dred Scott versus Stanford, the 1857 case. And it provides a very emphatic answer to the question of how do you reconcile liberty and its antithesis. Dred Scott, as you all know, is a Black man held in bondage and sued for his freedom on the ground that having lived in a free state and a free territory, he was therefore a free man. The question as presented by the Supreme Court of the United States is as follows. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights, privileges, immunities granted by that instrument to the citizen? In my view, Dred Scott poses the fundamental question of American democracy. It is a question that continues to haunt us, and is a question with which we have been struggling really since the founding, which is whether the Constitution was intended to benefit Black people or non-white people. So recall here the preamble, we the people. We the people are the people who created the Constitution to secure the blessings of liberty to ourselves and to our posterity. So then the fundamental question, who is included in we the people? And does it include people other than white people? And specifically, does it include Black people? So return to Dred Scott once more. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument? There are two parts of that inquiry, and I want to slow down and think about both aspects of it. The first half, can a Negro become a member of the political community, rightly deserves our attention, and it is the genesis, the point of departure for my inquiry. But the second half, as the court says, and as such become entitled to the rights and privileges and immunities guaranteed by that instrument, also deserves our attention. The question that it poses, that second half, is while there is an expressive aspect to belonging and citizenship, it's much more than that. So first, on the expressive aspect, now allow me here to repair to the work of the distinguished political theorist Judith Shklar, that citizenship is a matter of social standing. And I stand with Shklar that voting and citizenship is about social standing, and that matters, that's important. But it's much more than that, and this is the point that the second half of the inquiry points us to. It's not just about social standing, it is also instrumental. As the preamble recognizes, we the people form this union for a purpose, not just to establish our social standing, but to secure the blessings of liberty to ourselves and our posterity. Or as Dred Scott would put it, those folks who are entitled to the rights, privileges, and immunities guaranteed by that instrument. So these were the stakes. The stakes were not simply standing, that's important, social standing, but the stakes are also who are the folks who are entitled to bear and pick the fruits of governance? Who are the beneficiaries of an organized political community? Those are the people that, for whom the enterprise was intended. So Dred Scott went on to say, in a manner that is self-evident, the words people of the United States and citizens both describe the political body who form the sovereignty and who hold the power and conduct the government through their representatives. Right? Again, let me pause. The people who form the body, but also who hold the power and conduct government through their representatives. And the court then went on to say they are what we familiarly call the sovereign people. The question before us is whether Black people compose a portion of this people, this is the court, Dred Scott still speaking, and are constituent members of the sovereignty. Are they sovereign? Translated into, from the legalese into modern parlance, the court could have very well have said, do Black lives matter? Dred Scott's emphatic and clear answer, and here I quote again, we think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. Right? The court finds it absurd, as many of you know, that a constitution founded on the basis of liberty could have compromised with slavery and extended its benefits to those people. So Dred Scott, in my view, provides the most honest and clearest answer to our question. No, Black lives do not matter. Now, as we all know, Dred Scott was not the final answer. We fought a civil war over this framework, over this question, over these problems. And the Civil War gave birth to the Reconstruction Amendments, which purported to fully include Black people and non-white people within the conception of we the people. So that way, we the people does not simply mean and include we the right people. The Civil War, the Reconstruction Amendments, the Reconstruction era rejected the answer provided by Dred Scott. But as it turned out, as we know our history, this was a partial rejection. So even though following the Civil War, we adopted the 13th Amendment, neither slavery nor involuntary servitude shall exist within the United States. The 14th Amendment, all persons born or naturalized in the United States are citizens of the United States. No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. Right? So 3 fundamental moves that attempted to restructure the American polity to make it much more inclusive. And for a while, that did happen, right? And we did make progress. But this was not meant to last forever. And so within a period of 10 or so years, the Reconstruction agenda had its knees cut from, its legs cut from underneath it. So here's one specific example. Using its powers under the 13th and 14th Amendment, Congress passed the Civil Rights Act of 1875. The act prohibited racial segregation in public accommodations, such as motels, restaurants, theaters, and public transportation. But in 1883, the Supreme Court held that Congress did not have the power to pass the most critical provisions of the Civil Rights Act of 1875, and the court justified its decision in the following way. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of mere citizen and ceases to be the special favorites of the laws. Again, there's something that's interesting and fascinating, though perhaps morbidly so, with the court's decision in the civil rights cases. Right, what's fascinating is the court says there is a station of mere equality, but not much more than that. And we're thinking about 1865, and if you remember your history, 1875 with respect to the Civil Rights Act, if you remember your history, 1863, 1865, 1868, 1870, so the passage of the 13th, 14th, and 15th Amendments, you're thinking this is not too long ago, within 10 years or so, in which we tried to create a different structure, and the court saying there is a category of mere citizen, equal standing, but that's all that we can afford. You can no longer be the special favorite of the laws. It is up to you to make your own way. So from that context, the end of Reconstruction, we morphed right into legalized Jim Crow. And so the next stop here is Plessy versus Ferguson. Homer Plessy challenged a Louisiana law requiring racial segregation of railway cars, and the Supreme Court ruled that the law was constitutional. And the court said, laws permitting and even requiring the separation of the races and places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other. Louisiana, therefore, is at liberty to act with reference to the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. The court then concluded it is a fallacy to assume that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction on it. These cases, Plessy versus Ferguson as exemplary, but the civil rights cases, those are our constitutional foundation. Again, with Dred Scott, although impacted by the Civil War and the Reconstruction amendments, they provide a similar framework, which is, yes, the Constitution includes folks of color, but it will only go so far. And so if you believe yourself to be unequal, that is not a function of state action. That is simply because it is within you believe yourself to be unequal. That is your question and your issue. These are the types of answers that the court provides to Black people asking to be treated functionally, formally, instrumentally as full citizens. And so here, a quote from Plessy, but recall the court in the civil rights cases, when the government has secured to each of its citizens equal rights before the law and equal opportunities for improvement and progress, it has accomplished the end for which it was organized. Formal equality here, right, this is me speaking, formal equality defined as separation but equal is all that the government is required to do. Now back to the court in Plessy. The government has performed all of the functions respecting social advantages for which it is endowed. Legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. And finally, the kicker here, if one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same place. Once again, when the question is, does we, the people, fully include the non-white people? The answer is a qualified, perhaps yes, perhaps maybe, but not fully so. Now, of course, Plessy was repudiated by Brown versus Board of Education, the landmark Supreme Court case that sought to dismantle the legal doctrine of Jim Crow segregation. But we also know that Brown was not the end. It was only part of an ongoing struggle. So what is it that the struggle of full inclusion tell us? What is the lesson that we have learned so far? So consider two thoughts, one from the great critical race theorist, Derek Bell, and the other from the great jurist, Thurgood Marshall. First, Bell. Racism is a permanent feature of our landscape. The battle against white supremacy is an ever-present one. And this means that the battle of belonging by Black people and the spaces in which they find themselves is also an ever-present one. And now Marshall. We must refuse to acquiesce to outdated notions of liberty, justice, and equality. We must strive to be better. So what does this mean concretely, right? So first, again, the Bell lesson. Racism is a permanent feature of our landscape. It is the thing for which we'll continue to fight for. The battle against white supremacy is an ever-present one. And the battle for belonging is one that folks of color will always find themselves fighting. And Marshall, once again, we must continue to fight against outdated notions of liberty, justice, and equality. We must strive to be better. So what does this mean? And here I come to the last third of my talk. In a recent article reviewing the book, How to Be Anti-Racist by Ibram Kendi, the linguist John McWhorter and reviewer criticizes Kendi because Kendi says that all racial disparities are due to racism. McWhorter calls this a dire foundational assumption. McWhorter then goes on to provide a different explanation. Culture matters as well as society and how groups fare over time. And the history of Black Americans does not somehow exempt us from this basic aspect of humanity. Now, interestingly, if you've been following along relatively closely, you can see how this explanation, in fact, links fairly easily to what the court said in Plessy, to what the court said in the civil rights cases, and then maybe even to what the court said in Dred Scott. If you find yourself in a position of inequality, it is not because of law, it is not because of structure, it is not because of subordination, it is because of what you have done yourself. And law cannot make you equal. Cultural factors can live beyond what conditioned them. As a legal academic, I find McWhorter's explanation perplexing, but it is reflective of a powerful strand of the courts, of our court's long jurisprudence. Fundamental to the equality agenda is the idea that law does not bear responsibility for the unequal outcomes in which we find ourselves when we're thinking about the question and the problem of racial subordination. And I will submit that fundamental to the idea is also the conception that we, the people, does not fully include the non-white people. McWhorter's explanation, dressed in modern garb, ignores how law has structured racial inequality, how the Constitution has made a compromise with white supremacy. And while law, including the Constitution, federal statutes, and Supreme Court doctrine, has eventually evolved, right? While we have made racial progress, the modal manifestation of racial inequality in the 21st century, law has failed to respond to the modal manifestation of racial equality in the 21st century. So we have made progress in a similar way that when we moved from the Dred Scott regime to the Reconstruction framework, when we moved from legalized slavery to Jim Crow, you could say, yes, of course we have made progress. And when we moved from Jim Crow to the civil rights era, certainly we have made progress. But in this post-civil rights moment, the question then becomes, how can law fully include the modal manifestations of racial inequality for our century? How can the telos of anti-discrimination doctrine be reoriented from one that safeguards the equality claims of people of color? So here's the dilemma for our moment. The dilemma for our moment is that I think there's an emerging racial equality within constitutional jurisprudence that is deeply significant. Because while it compels the state to be racially inattentive to the concerns, while it compels the state to be attentive to formal inequality, it also compels the state to be inattentive to the concerns of citizens of color when those concerns are find themselves and are framed in race-conscious terms. And so the battle for formal inclusion is one that cannot be, is a battle that cannot be won until and unless we can account for the disparate impact inequality in which people of color battle daily. right? Until the modal claims of racial inequality of folks of color are recognized by the constitutional framework and structure. So allow me to provide one example, and then I will close with some thoughts. So the example here is the other case that haunts me. So I've given you essentially the highlights of the cases that haunt me, starting with Dred Scott, then Plessy, with a short detour in the civil rights cases. But here, this is the 2007 case of Parents Involved in Community School District versus Seattle. Parents Involved is a consolidation of two cases in which white plaintiffs challenged the voluntary desegregation programs in Seattle, Washington, and Louisville, Kentucky. And an opinion announcing the decision of the court, but the reasoning of only a plurality of justices, Chief Justice Roberts struck down the student assignment plans, and he concluded that the government-sponsored race-conscious voluntary school desegregation programs, which were designed admittedly to address racial inequality or educational inequality and racial isolationism, are the equivalent to government-enforced school segregation apartheid regime and validated in Brown versus Board of Education. Now, I hope that most find that this equivalence truly preposterous. That is, one could disagree and conclude that voluntary race-conscious desegregation programs raise equality concerns under our Constitution, but to equate them to government-enforced school segregation apartheid regimes is either to be ignorant of our history, and I don't think the Chief Justice is ignorant of our history, but then is deeply disingenuous. But even more than that, in this opinion, was remarkable about the Chief Justice's opinion, from my perspective, is that it explicitly exhibited a great solicitude for the white plaintiffs in the case. For example, the Chief Justice relayed with a very commendable sensitivity the fact that one of the plaintiffs suffered from a learning disability and has ADHD. But in sharp contrast, and then the contrast is sharp because of the sensitivity displayed by the Chief Justice to the plaintiffs, his opinion displayed no evident concern for children of color who are the object of the government's attention and will be impacted by his decision. So here is the government saying, local governments and state governments saying, look, we want to provide a much more inclusive environment for our students. So how should we do that, right? The Chief Justice believes that that's the equivalent of apartheid and tells us, how the plaintiffs are going to be impacted, but really shows no clear concern for either the impact of the decision or how the government was attempting to accommodate a number of different types of interests. So the most that he could muster was the blithe admonition that so many of you are familiar with: the way to stop discrimination on the basis of race is to stop discrimination on the basis of race. Remarkably, the Chief Justice's tone prompted Justice Kennedy, who was by no means a liberal on race issues, and who at the time assumed Justice O'Connor's mantle as a swing justice on many issues. It led him to characterize the Chief Justice's views as, I quote, inconsistent in both its approach and its implications with the history, meaning, and reach of the Equal Protection Clause, not sufficient as a postulate to decide these cases, and too dismissive of the legitimate interests government has in ensuring all people have equal opportunity regardless of race. Justice Kennedy's concurrence in Parents Involved is remarkable for its explicit rejection of colorblindness as a universal constitutional principle, and his willingness to squarely face up to the reality of racial inequality. In a thoughtful passage characterized by its raw honesty, Kennedy acknowledged that from the perspective of a person of color, de facto inequality may differ only slightly from de jure or legal discrimination. Moreover, striking the pose, if only for a minute, of a critical race theorist, he conceded that the distinction between de facto and de jure racial inequality is dubious, given that the relationship between law and society is, and here I quote again, amorphous, both as a historical matter and as a matter of present day finding of fact. Therefore, neither law nor society can escape responsibility for persisting injustices. Interestingly, the most consequential debate in Parents Involved was not between the liberals and the conservatives on the court. The most consequential debate was between Chief Justice Roberts and the three justices that agreed with him, aligned against Justice Kennedy, who argued that the court should not compel the state to be completely indifferent to the educational needs of Black and brown children. Right? So the argument is, can the state be totally indifferent or just a little bit indifferent? This is the equality frame in which we currently find ourselves. This is the question why we must continue to ask, to what extent does we, the people, include others that are non-white? Justice Kennedy argued that in the court's pursuit of protecting innocent white victims, the state must also be permitted to pay at least some lip service to the educational needs of non-whites. How far have we come then from Brown versus Board of Education? Right? You could see, we might believe that this post-civil rights framework gives us some reason to hope, but really we're arguing over a narrow frame. So then where do we go from here? First, some quick observations, and then perhaps some concrete solutions, at least as concrete as a law professor can offer. So, summary observations, three particular one. First, racial progress is not linear. Right? There is progress, 2 steps forward, but 1 step back. It is not linear. Second, racial progress is contingent. Right? It is contingent upon the politics of the moment, is contingent upon social circumstances, is contingent upon will, but it is contingent. Third, racial progress is deeply contested. Right? Within that background understanding, when we look, that helps us to make sense of the history, the short history that I ran through in the last 20 minutes. That yes, we've made racial progress, but it is by no means linear. And it is contingent on a series of things, including composition of the court or the political process at a particular moment, or what was going on within our society, and it is deeply contested. So now some concrete steps. First, inclusion is about outcomes. It is not about attitudes. So from my perspective, what does this mean? It means that we need to think about what the absolute outcomes are. Right? So to the extent that people want to be anti-racist, I think that's great. But really, for me, what matters are, what are the outcome measures? And are we seeing a disparate impact in those outcome measures in which we think are significant to us, are salient to us? And we should always be thinking about the outcome measures. To me, the outcome measures are the 21st century fundamental frame of racial equality and racial inequality. And so what that means from a doctrinal perspective, that is that we need to maintain and expand disparate impact doctrine and disparate impact analysis, because disparate impact is critical to inclusion. It actually tells us whether people of color really do belong and whether they are excluded from a particular domain. Racial civil rights activists need to make the case rhetorically, intellectually, doctrinally for the preservation and expansion of disparate impact doctrine. First concrete step. Second, racial inclusion is often indicative of a deeper problem. So I study the Voting Rights Act and voting rights. And when you look at the voting rights, one of the things that you saw is that yes, there was a significant problem in voting that was related to racial discrimination, without a doubt about it. But the barriers to voting that made it harder for Black people to vote also made it hard for white people to vote. Racial discrimination in voting was indicative of a problem that we had with voting much more broadly. Race in this context is diagnostic. So we should also think about expanding the pie for everyone. Inclusion ought to bring more people to the table. We should think about providing substantive rights that enables all of us to flourish as citizens or members of this polity. Third, sites of inclusion are multi-level. So often we think about these questions at a national level, but we should think about them in whatever institutions in which we find ourselves: national, state, local, law schools, whatever civic, whatever economic, whatever state, non-state institutions in which we find ourselves. The fight for inclusion is one that must be waged at many and multiple levels. And we should not focus exclusively on what is going on at the national level, because there are multiple sites and those sites are fundamentally important. But finally, inclusion is costly. Making room for people who have been excluded will necessarily exclude those who were always seated at the table or those who wielded a disproportionate amount of power. Inclusion will cost some people material gains. Changing the school system to make it much more inclusive might mean that some people might have to pay more in taxes. And inclusion in this context, remember my point here, inclusion in this context doesn't mean bringing more Black or brown faces simply. It means that looking at the outcome variables and saying, have we created schools in which children can learn without their learning and their ability to do well on whatever subject matter test we want to give them, or whatever the outcome variable is, where race is not an indication of how well or that they will do on those metrics, right? Inclusion costs. And the question is whether we're prepared to pay the cost. And here now I conclude. The fight for racial equality and for racial rights and for inclusion in the 21st century is not the fight of the 20th, nor the fight of the 19th. And that is a good thing. We have overcome. We have overcome much, and we should celebrate. But the task of inclusion, of making sure that we the people includes all the people, not just we the white people, is a task that remains to be accomplished. So if we want to fully reject Dred Scott's answer, we have miles and perhaps miles to go before we rest. Thank you.
Thank you, Professor Charles, so much for that talk. It was fabulous. So now I want to open it up to the audience for questions and answers. And I will direct you down to the Q&A. Can you hear me there? Yep, I'm going to direct people down to the Q&A button if you have questions down there. And I'm going to start with the first question that I received there, which goes to the Constitution as a vessel for a lot of the change that you've been talking about. And being struck by the idea that racial progress is contingent on society, on the court, on the political process. The question said, if all of those come together, is our constitutional text up for the challenge? Right? Can it do what it needs to do?
I definitely think our constitutional text is up for the challenge. The question for the text, for example, is what do we mean by equality? We have adopted various forms of that understanding. As I said, I study the Voting Rights Act, and part of what's interesting there is a court that had a particular understanding of equality in 1965 decided to expand its conception of what equality means to include disparate impact and measures under the Voting Rights Act that perhaps a prior court 10, 20, 30 years earlier would have rejected, and a later court 50 years earlier in Shelby County rejected, right? So the tools that we have within our constitutional framework, they are deeply flexible and they can accommodate different conceptions. And it's up to us to articulate those conceptions and to enforce them within our legal and constitutional system.
Thank you. All right, going over the Q&A, back to the Q&A. Thank you for this lecture. Can you address the possible significance of Justice Thomas's concurring opinion and his dispute with Breyer to your assessment of the Supreme Court as currently constituted and of parents involved?
Sure. So Justice Thomas, I think, has a very interesting viewpoint on those questions. So his particular viewpoint, often and generally, is the extent to which race is being used not because people, especially white elites, actually care about equality, but that they are using race as a way of undermining Black rights, and the conception that anything that is Black schools, Black children sitting next to each other are inherently devalued. And in order for the thing to have value, it must be that it must have proximity to whiteness, right? So from a pseudo Black nationalist perspective, Justice Thomas's views here seem to have some appeal. That is, the appeal is Blackness has its own inherent value and is not dependent upon its relative proximity to whiteness. And so we shouldn't think about the fact that we have schools that may be predominantly Black as schools that are not integrated, as separation, and therefore there's something wrong with it, that integration or segregation is the legal term of art. It means state-sponsored, and it doesn't simply mean the fact that Black people live in similar neighborhoods and therefore they go to school together, and that's a problem. In order to remedy that, what you actually need is a proximity to whiteness, right? So from a superficial Black nationalist, neo-Black nationalist perspective, that seems to have some attraction, but of course it denies the reality, from my perspective anyway, the reality of the subpar and inadequate schooling in which some Black kids are subject to. So I would have no problems. I mean, I would have no issues with Justice Thomas if the argument were, we are going to try to invest and make sure that the outcome of Black children are as strong and as equal to those of white kids. It's not going to be about integration or proximity to whiteness. Those are going to be our outcome variables. If that were the case, that I would be fine with it. But that's actually not the reality. The reality is that too many kids of color are attending schools not just separated from other races, but also the quality of the education, the investment in their education, and their outcomes are not what we ought to expect. And where you see better outcomes are in the integrated school systems, and where people have choices in those school systems. So I think we have to deal with the reality. And from my perspective, Justice Thomas's opinion provides a superficial, attractive framework, but does not fully address the lived lives of children attending often subpar schooling systems.
Thank you. Another question. You mentioned the importance of including state and local jurisdictions and efforts toward progress. Does that run the risk of creating islands of tolerance? And how do we nationalize this country's often ignored positive rights tradition?
Sure, that's also another great question. I think it is important to nationalize certain rights. So I don't view this as an either or approach. My argument simply is, let's not just focus on the task of nationalization. That's an important task. It's an important quest, and we must continue that fight. But at the same time, there are places within our local or state jurisdictions or the institutions in which we find ourselves, and in which we can improve the quality of life for marginalized groups and marginalized people. And so let's not ignore the state and local level to the exclusion and prefer simply nationalizing fights. And so, yeah, one possibility is on the road toward nationalization, you might have pockets and islands of inclusivity as well as pockets and islands of exclusivity. But fundamentally, this is the system that we have. And the question is, how can we work best within it and maximize its advantages? So I recognize that possibility, but I'm not arguing and articulating an either-or approach.
Thank you. Next question from Professor Chambers. Does the Constitution require inclusion, or is inclusion a matter of will? Do Americans or law schools have the will to be inclusive?
Professor Chambers can answer that question much better than I can. I'm glad that you identified him so that we can out him and give him grief. All right, so I don't think the Constitution, I think it's a great question. I don't think the Constitution requires inclusion. I think inclusion is a matter of what are our norms and values of equality, right? And so I think that the constitutional framework can live with different understandings of equality, including narrowly defined formal equality, which we lived with for a very long time. The question for our society, I think all has to be and always has to be for a particular society, what are our values? And how can those values be reflected in the document that we believe governs us in our society best and well? And so I think that's why it's important for race equality activists in this moment to offer their vision of equality. And it will be, as I mentioned, a contested vision, right? And one can use the constitutional framework as the vehicle or the vessel within which to rest it. But I don't know that it's one that one can say is compelled by our constitutional framework.
Thank you. So our next question is from Danielle Conway, Dean at Penn State Dickinson Law School, and who says, by the way, that you have fed her soul this evening. And her question is, are there aspects of inclusion that do not cost and thus are truly non-rivalrous? She's thinking of gains made by white society when we expand inclusion, which essentially offset costs.
Mm-hmm. Another great scholar and another great question, and I will look forward to returning the favor to these people. Okay, so I have to say, I don't think that there are gains in favor of inclusion that do not cost. Though Dean may be thinking about things that I'm not thinking about, but I think when you look at all gains toward inclusion that are non-expressive, but even expressive gains, right? That is when take Judith Shklar's idea of standing, but also even Jeremy Waldron's conception of dignity. When somebody else is brought up to your level, that that comparatively brings you down. And deans actually know this really well when it comes to salary negotiations, right? Somebody who's really happy with their salary find out that somebody else is making more than they are, right? Or they were making more than somebody and they're at their level, right? All of a sudden, right, there's just sense. So even though that's material, but part of it is expressive. The idea that that my standing when I'm above you actually matters to me in an expressive way and not just materially. So there are psychic costs that might be incurred even with respect to expressive inclusion, much less the material gains and material costs of providing more seats for people at the table, whatever metaphorical table and framework that we want to that we want to think about. And this is why I really do want to be straightforward and honest about the cost, because so often we say we want equality, and so often we say we want to be better, all of us, right? But few of us are willing to prepare to pay the cost and disempower ourselves. So part of what's interesting for me thinking about voting and voting rights, that people are not willing to give up political power. They recognize that there's a cost. It means that sometimes you're not going to get your way, right? If there are other people who have voice in the matter. But we have to be honest that there are costs to inclusion. And I have a hard time thinking about areas in which those costs are either minimal or non-existent.
Thank you. Next question. You mentioned that the equality movement is not the same as it was in the 19th and 20th centuries. So is it possible that we need a new document to address we the people now? The founding fathers had a perspective that doesn't seem to fairly address the people now.
So as I addressed in one of the prior questions, I think that our constitutional framework is sufficiently capacious. There might be some things that we might do differently. So for example, perhaps some of us, if we were starting on a blank slate, we might rethink what federalism means, right? So some of us might think that it would be easier, and some might argue actually harder, to achieve equality in either a deeply centralized polity or a deeply decentralized polity, such as the one that we have roughly, although much less decentralized in the 21st century than it was at the founding. So part of what's interesting about our constitution, our constitutional jurisprudence, our constitutional framework is in fact how flexible it is, right? And it has accounted for both through statutes as well as through constitutional interpretation, different equality claims. Right. So many of you are aware of the Supreme Court's recent Title VII decision incorporating the equality claims within a statutory framework of gay and transgender citizens. Right. So our framework is actually flexible. And to put a point on the question asked by Professor Chambers, it is in many ways a question of will and imagination. Right, to incorporate different equality claims within an extremely flexible constitutional jurisprudence document, sets of cases, statutes, right? So the whole system, I think, has a fair amount of flexibility.
Thank you. And I'm going to do two more questions just because I'm watching the time here. Next question. Thank you for taking the time to speak with us tonight. Can you address the 13th Amendment's except as punishment for crime caveat? How do you see our Constitution addressing the vast racial inequalities within our criminal justice system that this phrase has resulted in?
Thank you. So again, so there are two ways of interpreting the 13th Amendment's provision. One could simply say that it licenses the current racial carceral system that we have. And what has been great over the last few years is the amount of attention the carceral state has received. And so the question is, do we need to amend the Constitution? Again, I'm going to stick with my consistent answer. Just give one very clear example. We interpret the First Amendment to apply both to Congress and to the states, notwithstanding the specific language of the First Amendment. Congress shall, right? So Congress shall means not just Congress, but also means the states. So the point is that the language of the Constitution sometimes constrains and sometimes dictates outcomes, but more often than not, what dictates outcomes is not the language of the Constitution. It is the poverty of our imagination. It is our racism. It is our lack of will, right? These other types of factors that dictate outcomes, because sometimes the text is clear, and notwithstanding the clarity of the text, we can encompass a broad conception of speech rights, as to stick with that example, right? So I don't think the 13th Amendment is the problem. I think the problem is that we have not been sufficiently attentive to the way that we've reimagine the slavery system, and how we've shunted people into the carceral system. And now that I think we are beginning to think about that, then hopefully we will develop a jurisprudence who will account for it.
So I'm noticing that it's 7:01, but I'm hoping you'll take one last question. I know we have many here in the queue, but I'm going to slide in one more.
Yes.
And the question says, thank you for this phenomenal lecture. You listed among your concrete steps the idea that inclusion is about outcomes, as well as the suggestion that we must engage in a multiplicity of sites, including in legal education. Could you share observations about what it looks like for legal education to create inclusive outcomes?
Sure. So let me, this is the last question, but why not I can just disappear after this. So let me throw a few bombs. Okay, so there are lots of places that we can look, right? We could look at our faculties and we could say, all right, how diverse are those faculties? And we could just ask about outcomes. We could look at our student bodies and say, how diverse are those student bodies? And we just ask about outcomes. We could look at the job prospects of our various students, and just ask, all right, how are the job prospects of our various students? Are there differentials on the basis of using race as our category, as our outcome variable? Are there differentials on the basis of race? We could look at satisfaction with the profession, right? We could look at opportunities for clerkships. So there are many. We could look at what the courses that are taught in the classroom, right? So there are many places. So, and again, this is nothing, we don't think about, look, are people racist? Are they not racist? Okay, that's fine. People can engage in that discussion. That is not my bailiwick. What I'm interested in is just asking, let's just look at these outcomes and then let's figure out how to work backwards. So how do we get to a diverse faculty, right? If we're committed to that, how do we get a diverse faculty? I would get diverse sets of student bodies. I would make sure that opportunities are open to everybody, and not foreclosed by their racial identities and other things that we might care about, right? So that's the place and the way that I would think about it with respect to law schools, being fairly ruthless about holding ourselves to account where we see racial disparities and the institutions in which we find ourselves.
Thank you so much. And thank you for joining us this evening. It was truly a pleasure to have you here.
Thank you for having me, and thank you to you as well, Professor Erickson, for extending the invitation and all of your support, and everybody's support in making this lecture happen. But my special thanks to you as well.
Well, we are so grateful to have you here to help us kick off this unusual academic year. But it's been truly a pleasure, and I think I speak for all of us when I say thank you. Thank you to everyone. Hopefully, I know there are lots more questions in the Q&A. Hopefully this will spark a conversation still here in our law school community with all of these questions. Thank you, everyone, and take care.
Bye.